I'd like to talk a little bit about children in a marriage. Obviously, when you divorce, you're no longer spouses, but you're still parents. It's an incredibly difficult transition for people whose marriage has ended to find a basis for a civil, productive co-parenting relationship. The policy of the court is to facilitate the creation of that relationship. They do that through mediation services, through custody evaluation services, and other kinds of resources available to the court. Co-parenting programs, counseling, various other things. The legal issues are child custody, and that's interwoven with visitation, and that ultimately impacts child support. So custody is there are a series of issues. We want to decide who the children are going to live with, and we have certain kinds of definitions about that. We have joint legal custody, or we have legal custody. Legal custody is to put people on a level playing field and to give you equal decision-making authority for the major decisions in your children's lives. The younger your children are, the more the adults make those decisions. The older your children are, increasingly a child will have some say in regard to those issues, when they see the parents, who they live with, those kinds of things. That generally does not happen until a child is 14 years or older. It's fairly rare to see custody cases in the courtroom for children who are over the age of 14. If the parties cannot agree on a co-parenting plan, the court is required to send them to mediation. There's an agency of or arm of the court system called Family Court Services, and they have a mediation department. If you go to court and there's, again, no co-parenting agreement, the court sends you to mediation. There's several kinds of mediation. The initial one is a confidential session with a court-appointed mediator who has specific forensic training to assist people in reaching an agreement. If you reach an agreement, great. Progress has been made. It's an early point in the case, and it's better for your children because you now have an agreement. If you don't reach an agreement, they'll send you to a more intense or a more involved mediation, where if no agreement is reached, the mediator will make recommendations. The primary way the court deals with custody is to try to create a schedule of how to allocate the time between the parents. A very typical schedule would be that dad has visitation every other weekend. The kids live with mom during the week. Mom gets some weekend time too. There's an overlay of a holiday schedule and perhaps extended time with a non-custodial parent during the summertime. So you end up expressing it in a percentage, which is called the timeshare factor or the visitation factor. So if dad sees the kids every other week, has a share of the holidays and extended time in the summer, he may have 30 or 35% of the time. Mom gets 65 or 70% of the time. A lot of parents strive for a 50-50 timeshare, but it can get very complicated. You really have to consider what the proposal is, because it can be very stressful for your children if they have multiple transitions during the week or month. Imagine yourself going back and forth between your parents' house 2 or 3 times a week or 5 or 6 times a month. It can be very difficult for children. So you really need to think these things through. You need to look at your job and your spouse's job and where the kids are in school and what your family traditions are in terms of holidays and summer times, and see what you can do to arrive at a fair agreement that is in the best interest of your children. And that is the standard the judge makes decisions by, the best interest of the children. because there have been so many cases that have gone through the system, there's some pretty well-worn grooves about how this works, about how you divide holidays and what you do in the summer. The threshold decisions are legal custody and physical custody. Again, the judge will generally grant joint legal custody to both parents to give them equal authority in the major decision-making for their children. Physical custody is who the children primarily reside with. It doesn't necessarily favor one side or the other. These are just useful definitions for organizing the co-parenting plan, expressing what's going on with the co-parenting plan, and allowing some clarity into how the co-parenting plan works. It can be very involved. If the parents don't agree, you can go from mediation to what's currently called a fact-finding inquiry done by a court investigator. And the next level above that is something called a custody evaluation. Mediation is a no-fee service. That's incorporated into the filing fee you pay when you file your first papers to divorce. After that, if you go to court fact-finding inquiries or custody evaluations, they're fee-based. The fact-finding inquiry is a low of $350 to $700. Generally, each party pays half of that. Sometimes one party has to advance the fees, and it's pretty hard to recover them if you advance them, but sometimes that's how it works depending upon the party's financial circumstances. Custody evaluations are running about $2,500 to $3,000. Even more expensive for cases where parties can really afford really high experts like psychologists rather than therapists. I was in court recently and heard of an excellent custody evaluator in the county in San Jose. The lowest fee for this expert was $6,000. So these can be very expensive services. In order to move through these fact-finding inquiries and these custody evaluations, you generally need 3 or 4 months. Sometimes it takes longer. Sometimes it takes much longer. So when you discuss these issues with your attorney, you really need to get a good idea of what the issues are, what the likelihood of agreement between the parties is. If there is no agreement, what resources in the court system you might use and what you can afford to do. So there is a lot of thought that needs to be given to this. The other comment I will make is, for most people, their children are what is most important to them. So the issues in custody and visitation can be very intense, because it's so meaningful to the parties and they're so concerned about the welfare of their children. Once you file those divorce papers and one spouse moves out of the house and you see the effect on your children of the disruption in their lives, it can be very hard on everybody emotionally. So you need to consider those things in divorce. You may want to look at going to a counselor with your divorcing spouse to look at how you're going to divorce and how these issues are all going to play out. The better prepared you are, the less you will pay, the better outcome you will get. So I have clients come into my office who have not quite decided to get a divorce. They're educating themselves. They're investigating what's going to happen, and that's really smart. But sometimes circumstances force themselves on you. Sometimes you receive paper from your spouse that says, I'm divorcing you, and it's a surprise occasionally. Most people know what the state of their marriage is, but some people are surprised by the decision to divorce. So preparation is really important, and the younger your children are, the more important it is to look at the effects on them. But children at every stage, even older children in their middle and late teens, are it's so rare to see a child who is better off with divorce. It's very rare. Once in a while, there's so much conflict in the family home that the kids feel relief when their parents separate. But in probably hundreds and hundreds of cases I've done over the years, there's probably only maybe 2 or 3 where the adult children said, recalling their parents' divorce, that they were better off that their parents divorced.